I'm audible and clear? Okay, thank you. So, continuing with the series of solving the sample questions for CUET, today I'll be dealing with the legal studies paper. So, starting with the very first question. An international organization that was set up in the year 1990 to achieve social justice. So, can I get some answers for that? So, the options are International Labour Organization, World Bank, International Monetary Fund, and World Health Organization. So if we look into the timeline that the period 1919, we can actually see that another significant thing that was happening in that time period was World War I. That was from the year 1914 to 1918. So the answer for the question is International Labour Organization, that is option A. So International Labour Organization was something which was created in 1990 as a part of Treaty of Versailles that ended the World War I. So the very aim with the International Labour Organization was formed was to achieve social justice. So the answer for the same is option A. If no doubts, let's move to the second question. So the second question is, the International Criminal Court does not deal with one of the following crimes. Option A, crimes against humanity, B, crimes of aggression, then C, genocide, and option D, crimes against intellectual property. Any answers? Yes, the answer is crimes against intellectual property. So the International Criminal Court is actually a tribunal that was set up through the Rome Statute in the year 2002 with the very purpose of prosecuting criminals for 4 major crimes. So those include crimes against humanity, crimes of aggression, genocide, as well as war crimes. So crimes against intellectual property is not among those 4. So the answer is crimes against intellectual property. So that is not something which is within the purview of International Criminal Court. The option D, that is crimes against intellectual property. If no doubts, let's move to the third question. So the third question is, the Advocates Act was enacted in the year Any answers? So Advocates Act is an act that was enacted so as to amend and consolidate the law that is relating to the legal practitioners and to provide for the constitution of bar councils and all India bar councils. So it is the act that is regulating the legal professions in India, and which includes both the practice of law as well as the professional legal education. And the act came into existence in the year 1961. So this was the first unified act that came into the independent India. So the year is 1961. Moving to the fourth question. So that is the concept of public interest litigation release the locus standi. So hence it brought for the judicial activism through its non-adversarial approach. So the very question is as to what exactly locus standi means. So the options include rights of a person to receive damages, rights of a person to appear and be heard by a court, rights of a person to file an appeal before the High Court, and rights of a person to pardon from the court. So as to what exactly a public interest litigation is that, it's a form of litigation that is filed so as to safeguard or enforce the public interest. So before the advent of public interest litigation, judicial recourse or judicial remedy was specifically available only to the persons who suffered a legal injury by a reason. However, with the advent of the concept of public interest litigation, the aspect of legal rights of a person, or when the class of persons are actually violated by any reason, they can actually, if they are incapable of approaching the court, then a public spirited person can actually file a petition for the same. So that's how the aspect of locus standi changed with the advent of public interest litigation. And the very meaning of locus standi is that it's the right of a party to appear and to be heard by a court. So the question was just to know as to what exactly locus standi means, but since they have given a background as to the changes that brought in forth with respect to public interest litigation, just understand as to what was the change that was brought with respect to public interest litigation. So as to exact meaning of public interest litigation, it's nothing but it's a right of a person to appear and to be heard by a court. I hope that was clear. If no doubts, let's move to the next question. So what option is available for a law graduate if he or she wants to be instrumental in pursuing public policy making? I hope there was some error in the question. But yes, it's nothing but, so if any individual wants to be into, like a law graduate specifically wants to pursue public policy making, so what are the options? So the options are join a non-governmental organization, become a lecturer or assistant professor in some college or university, or join a law firm, or apply to serve as a legislative assistant under LAM. So what are the options for a law graduate? Joining a non-governmental organization? No, nothing with respect to public policy making. Or becoming a lecturer? Joining a law firm, specifically with respect to practicing a specific area only. So the answer is option D, apply to serve as a legislative assistant under LAM. So LAM is actually a fellowship that provides for the opportunity for the passionate youth so as to work with a member of parliament. So the answer is option D. So moving to the next question, that is, National Law University of Delhi conducts a separate entrance test called. So the provided answers are LSAT, LSAC, ALS, and LST. So All India Law Entrance Test is the one which is conducted by National Law University of Delhi. It's a national level exam. It's conducted every year so as to initiate the admission process for the candidates. So LSAT is also another national exam. Like it's an international level exam as well. If no doubts with respect to 6th question, we'll move to the 7th one. So an advocate on record is an advocate who has passed the qualifying examination conducted by the following. Like, what exactly is the qualifying examination, which is the authority which is having the right to conduct advocate on record examination. So options are Bar Council of India, Supreme Court, High Court, and State Bar Council. Any answers? So an advocate on record is an exam that is conducted by Supreme Court of India. That is, it is only the advocates who cleared the exam of AR will be able to practice in Supreme Court. So no advocate other than the advocate on record can actually appear and plead in Supreme Court unless he is instructed by the advocates on record. So the answer is Supreme Court of India. So advocate on record is an advocate who has passed the qualifying examination that is conducted by the Supreme Court of India. So moving to the next question. Which of the following is an advocate's duty towards the client? So there are several duties that as an advocate which he owes to client. So out of the following option, which is the answer? So the options available are appear in the matter where he or she is a witness. Not necessary actually. Because if he is a witness, just like he can actually approach the court by his own. Then bound to accept briefs. Then option C, suppress the matters or evidence. Then withdraw from the service. So the answer is option B. That is bound to accept briefs. Briefs in the sense that it's a duty of advocates who has to know what exactly the brief of the case while dealing with the case in the court. So advocate must know as to what is the nature of the case and on what exactly is the related and necessary facts of the case. So that's the aspect with respect to bound to accept the briefs. So withdraw from the service is a duty which it's something which he should not do. An advocate should not withdraw from the service once he had accepted the brief. So unless and until there is a valid reason for the same. Only in exigent circumstances, the advocates can actually withdraw the service. So he is bound to accept the briefs from client. So that was the answer for 8th one. Going towards the next question. Identify the constitutional provision of Indian ideal of respecting the international law and treaty obligation. So the options are Article 51 of the Constitution, Article 131, Article 253. Choose the correct option from the below. So Article 51 is something which sorry, there was a question. What does option B mean? Which was the question? Was it A? Okay. So we'll continue with the ninth question. So the constitutional provision in India, that is with respect to the international law treaty obligation, the ideal of respecting international law and treaty obligation. So actually Article 51 of the Constitution is the one which provides for the obligation to respect for international treaties. At the same time, Article 253 provides that it actually confers the powers of Parliament to make laws so as to implement international agreements. So going with that, it would be Article 51 and Article 253 of the Indian Constitution. So that would mean option A is the answer. Sorry, option C. So on towards the 10th question. Against the given international organizations in the order of their establishment, starting from the organization that was established first. So there are International Criminal Court, International Committee of Red Cross, World Health Organization, then International Court of Justice, and UNESCO, United Nations Educational, Scientific, and Cultural Organization. So we'll start with the establishment of those years. So International Criminal Court was actually established in the year 1860. No, that's the recent one. So it's 2002. Then the International Committee of the Red Cross was established in the year 1863. World Health Organization was established in the year 1948. International Court of Justice in the year 1945. And United Nations UNESCO was established in the year 1945. So yeah, International Court of Justice and UNESCO was established in the same year. So however, there was a difference with respect to the month in which it was established. So International Court of Justice was established in 26th June and UNESCO in the year 16th November. So yeah. So what would be the answer? So it's option C, B, E, D, C, A. So it's option C. I hope the years I wrote in the screen is visible. So I just reiterate the same. So International Criminal Court was established in the year 2002. So that is a recent one. And with respect to International Committee of the Red Cross in the year 1863, World Health Organization in 1948, International Court of Justice in 1945, and UNESCO in the year 1945 again. So while dealing with the CUET legal questions, like almost all the questions, so these are some of the sample questions from the previous year paper. So almost all the questions are from the textbook only, like that is the NCERT legal studies textbook of 11th and 12th. So you will be getting all the dates and everything that I'm discussing here in the NCERT textbook. So that should be your primary focus while preparing the CUET for legal studies paper for CUET. So that being said, let's move to the next question. As per the Bar Council of India, which of the following information cannot be published by advocates on their website? So, Bar Council rules provides that only 5 pieces of information can be put on the internet. So, which is the one that is cannot be published? His professional and academic qualification, yes, it can be published. So, 5 pieces of information that can be published. Let's just start the discussion with that. So, firstly, the name and the advocate or the firm, then the contact details, then details of the enrollment with the bar, then his professional and academic qualification, and the areas of practice. So these are the 5 pieces of information that can be published. Other than that, he cannot solicit his works. So the information which cannot be published in the advocates on the website is nothing but his fees and remuneration that is charged. So that should be avoided. So option B. So let's move to the 12th question. As a part of the process of impeachment, an inquiry is made into the grounds of removal of the judges. So what exactly is the ground for the removal include? So the process of the removal of judges is called an impeachment. And impeachment can be only on 2 grounds. And what are those 2 grounds? 2 grounds are here that is provided, but then the other 2 grounds are not as a part of impeachment. So the 2 grounds for impeachment is proven misbehavior and incapacity. So the answer would be it's the yes, and sorry. The grounds for removal include proven misbehavior and incapacity. So B and it's option B. Okay. So let's move to the next question, that is identify the bodies that were replaced by Supreme Court of India in the year 1950. So the Supreme Court of India in 1950 actually had replaced both Federal Court of India and Judicial Committee of Privy Council. So the answer is option B and C. So moving to the 14th question. Which of the following high courts enrolled Mrs. Cornelia Sorangi as the first Indian lady Vakil on 24th August 1921? option B. I hope Amrita is giving the answer for 14th question. If then the answer is B only, it's Allahabad High Court. So Allahabad High Court took the lead by enrolling Miss Cornelia Sorabji as the first Indian lady advocate on 24th August 1921. No, the answer is Allahabad High Court. So there were petitions in Calcutta High Court and Patna High Court by some other women practicing wakils, but it was the Allahabad High Court after a committee report came into the aspect of enrolling Cornelia Sorabji as the first Indian lady wakil. So that was a grade of practice that existed. So it's now only like we have the after the Advocates Act of 1961, we have a unified grade for practitioners or legal practitioners, that is advocate. But before that, there existed around 6 grades of practitioners, including wakil, muhtars, pleaders, and so on. And that were the categories of advocates there. Not very relevant, but just for your understanding. So yes, move on to the next question, 15th one. Choose the correct answer from the option. So Article 32, Article 131, Article 136, and Article 143. Article 32 is the writ jurisdiction. So whenever there is a violation of fundamental rights, you can approach the courts under the writ jurisdiction. Then Article 131. Article 131 is the original jurisdiction of the court. And Article 136 is the appellate jurisdiction. That is by special leave petition, whenever if you are not satisfied with the lower court's decision, you can approach Supreme Court under Article 136. And Article 143 is with respect to advisory jurisdiction. That is, President can seek advice from the Supreme Court in certain matters. So the answer is option B. So moving to the next question. After the magistrate forward a case of trial, which situation does the session court has the jurisdiction to initiate the proceedings? So imprisonment for 7 years or more, offence punishable with a term of 5 years, offence punishable with death, offence punishable with life imprisonment, or offence punishable with imprisonment of life for less than 2 years. So in respect of the offences that is punishable with death, as well as the offence punishable with life imprisonment and imprisonment for 7 years or more. So if in all these case scenarios, magistrate will be forwarding the same to the sessions court for the trial. So the answer is option A, C, and D. It's option C. So which of the following provisions of Code of Criminal Procedure and the CRPC provide that if a man was charged with a debt, the court could provide him with counsel upon his request. So free legal aid is the right that is conferred to citizens, and it is guaranteed under Constitution as well. It's Article 39A. Now it's coming under Directive Principles of State Policy. But however, as a matter of right, it is being accepted. And here in the question is specifically with respect to the provisions in CRPC that provides for the free legal aid. Very specific question actually. But however, it's provided there in the legal studies textbook, the NCERT 12th standard. So free legal aid under criminal law is coming under Section 340 Clause 1. So it provides that if a man was charged with the offence punishable with death, the court could provide him with a counsel upon his request. So now man will go unrepresented without a counsel. So it's a right that is guaranteed under Indian Constitution as well. Now it's under Directive Principles of State Policy only. So yeah, the question was with respect to the Criminal Procedure Code. But other than that, I think there are some more questions that is following specifically with respect to free legal aid. So moving to the next question. Which of the following is not an intellectual property right? Which of the following? So invention, artistic work, a garden, a simple, or a car. So which of the following is not an intellectual property rights? That's the question. So intellectual property rights are nothing but that is based on the intellect of a person. So that would actually refers to the legal rights that is given to an inventor or a creator to protect his invention or creation for a certain period of time. So some of the intellectual property rights would include copyright, trademark, then patents, and so on. So actually invention is coming under patents of intellectual property right. Then there is artistic work, that is also an intellectual property right. Simple is protected under trademark. So herein the answer is this is not coming under intellectual property right. So it's option C and E. So the answer will be B. So moving to the next question. Sanjeev sold 15 shisham trees to Harish, who cut them and used wood for furniture. Identify the nature of transfer. So the transfer as to whether it's a sale of movable property, whether it's a sale of immovable property, or lease or an exchange. So what exactly is the nature of the transfer? That is the question. So in this regard, it's pertinent to understand as to what exactly a movable property is. So movable property is nothing but it's one which it can be transferred from one place to another. So immobile property can be any property that is attached to earth. So in that regard, as to whether the trees that was handed over for using it as a furniture, what would be that? Would it be sale of mobile property or sale of immobile property? Even though immobile properties are those, yeah, option, yes. Option B is immobile property. Yes, the answer is that. So this was something which was clarified in the case of Shanti Bai versus State of Bombay. Shanti Bai versus State of Bombay. State of Bombay in the year 1958. So 1958. So in the year 1958, in that case, the distinction as to movable property and immobile property was actually observed. So it was clarified that if the intention is to reap fruits from the trees, then it would be regarded as an immobile property because it's still attached to earth. So, but if the intention is so as to cut down the trees and use it as a timber, it would be regarded as a movable property. So the answer is sale of movable property. Okay, sorry. The answer Nimisha told was B. Okay, sorry. So I got a confusion for that. So the answer is sale of movable property. Because it can be transferred once it is cut down. This was for the use of wood asset for furniture. So as held in the case of Shantabai versus State of Bombay, it would be regarded as a movable property because it is for cutting down. So the next question is, we click yes on an offer on a website. So this act of Ritwik accounts to what? So whether it's an offer, whether it's a proposal, whether it's an acceptance or a consideration. So what exactly is an offer? Offer or proposal, both are the first step in the formation of a contract. So when exactly is an offer or proposal is that when one person signifies to another his willingness. So Amrita told option C, acceptance, yes. The answer is right, but let me explain as to what exactly an offer or a proposal is. So when a person signifies to another his willingness to do or not to do certain things, it's called an offer. But at the same time, when an assent or a consent is given to that to the made offer, then that would be acceptance. So in this regard, as to whether clicking yes would that amount to an acceptance? Yes. By saying yes or no, okay, or clicking on I agree on an offer on a website also amounts to acceptance. So the answer is acceptance. So moving to the next question. So what exactly are these things as to what battery and assault, nuisance, defamation and negligence? It's again massive following. So battery and assault. So it's an unlawful physical application, the application of a physical force to another That is what exactly battery is, whereas an assault is an attempt to commit a battery or an act that causes another or creating a reasonable fear. In battery, there is a physical act, but whereas in assault, it's just a mental injury. So battery and assault would be physical or mental injury that is created to the claimant. Whereas as to what a nuisance is, it's the intrusion with one's enjoyment. So these all are coming under law of torts. Law of torts is a civil wrong. And yes, then defamation, yes. It is coming both under law of torts and law of crime. So defamation is nothing but when a person tries to tarnish the reputation of another person. So herein the reputation of a claimant is actually injured. And with respect to negligence, it's a careless behavior. So the answer is C. So almost all the provided principles were that of law of torts, but however, defamation, there's defamation under criminal law as well, but that would come under law of torts also. So moving to the next question. Second one. So yeah, these are two statutes, Indian Penal Code and Criminal Procedure Code. Then now there is cognizable offense and compoundable offense. As to what these are, yes. Coming to Indian Penal Code. So here in substantive criminal law. So what exactly is substantive criminal law is? It is a set of laws that actually govern as to how members of society are to behave. So it is in contrast to procedural law, because procedural law actually sets for the procedures for like making and administrating as well as enforcing the substantive law. So Indian Penal Code is nothing but it's a substantive criminal law, whereas Criminal Procedure Code is a procedural criminal law, because it is the statute that is providing for the procedures as to once an offense is committed. As to whether or not it's an offense is provided under Indian Penal Code, but however, as to what exactly is the procedure that is to be followed once an offense is identified is provided under Criminal Procedure Code. And cognizable offense. So, cognizable offense is nothing but where an offense where police officer can investigate without warrant from the court. So, it's a serious offenses. In cases of serious offenses, police officers can investigate without a warrant from the court. And with respect to compoundable offenses, offenses where the parties can settle their disputes by compromising. So, it will be less trivial in nature considered to that to non-compoundable offenses. Non-compoundable offenses when the offenses cannot be settled. In compoundable offenses, the offenses can be settled because it will be less serious in nature. So moving to the next question. Yes, that is again the question is with respect to free legal aid. I hope you remember the question that we discussed earlier with respect to the free legal aid that is provided under Criminal Procedure Code. That was specific provision that was provided under the Criminal Procedure Code. And herein the question is, which article of Indian Constitution reiterates the kind of an equality which shall promote access to justice for all by creating equal opportunity in the light of legal aid? So it's Article 39A. So this actually imposes an obligation on the state so as to provide free legal aid to ensure access to justice for all the citizens. So under this, state government is obligated to provide free legal access. So Article 19, Article 21 and Article 12, these are coming under fundamental rights. Article 19 is with respect to freedom of speech and expression, 21 right to life, and Article 12 with respect to the definition of the state. Definition of the state in the sense, fundamental rights are something which is guaranteed against the state. So what exactly the state is, or what constitutes state, is provided under Article 12. The definition of the state is provided under that. So the constitutional provisions are also important. So all the significant provisions are provided in the legal studies textbook. So when you study law constitution, just go through all the provisions that is provided in the textbook, because they are all important. So moving to the next question. So the question is, a common remedy for the breach of contract is awarding damages to the affected party. So the purpose of awarding this damage is to put the injured party in the same position as it would have been, as he would have been if the contract had not been breached. So this is in conformation with which principle or which doctrine? So the doctrine is doctrine of restitution. Doctrine of restitution actually deals with the awarding damages for the pecuniary loss that is incurred by the party to the contract. Pecuniary loss in the sense that monetary loss that is incurred by the party. So that is the very idea of the doctrine of restitution, wherein they are, that doctrine clearly provides that it is to put the injured party in the same position as he would have been if the contract had not been breached. So whenever there is a breach, the party should be compensated with the adequate amount. So that is doctrine of restitution, which is about the monetary damage that is to be provided. So the next question is here. Mehak has a litigation to determine her rights to a property that is situated at the Ram Court. So she is represented by a lawyer in the court of law who gathers evidence in the matter and participates in the cross-examination and scrutiny of evidence. So the judge patiently listens to the lawyer from both sides and then only decides the matter, and solely on the basis of evidence. So here the system of dispensing justice through hearing these both sides is under which law? So common law system, inquisitorial system, Roman law, or adversarial system. So as to what exactly an adversarial or inquisitorial system is that? In adversarial system, the parties in the legal proceeding develop their own theory of a case and gather evidence so as to support their claims, wherein there will be both counsels, that is defendant counsels will be there, as well as the plaintiff or the petitioner will be there. However, in the inquisitorial system, it is a judge or the decision maker that actually takes the center stage in dispensing the justice. So here, what all aspects were there? She is actually represented by a lawyer who gathers evidences in the matter, then participates in the cross-examination as well as the scrutiny of evidence. So all these points towards the fact that the judge is actually trying to get all these things from the parties itself. So that would be under adversarial system. So adversarial system is where the legal proceeding, wherein the judge try to gather all the evidence from the parties itself. So that is by hearing both the parties. That's what exactly an adversarial system is. So here in the instance scenario is that of an adversarial system. So the next question is, which of the following person is not entitled to free legal aid under Legal Services Authority Act of 1987? So the very aim of the free legal aid services that was introduced through the act was to provide legal aid to the competent, not the competent, to the weaker section of the society. So in that regard, of course, a person with economically sound background will be negated. So the answer is a person with economically sound background is not eligible for a free legal aid. So the next question is, identify the anti-corruption ombudsman organization in the Indian states. As to whether it's a Lokpal, Lok Ayukta, Chief Vigilance Office, or Central Vigilance Commission. So what exactly a Lokpal is? That is a representative. What exactly an ombudsman is? That is a representative. So a Lokpal is a representative or a caretaker of a person. He is an ombudsman in India. That's Lokpal. So it's for the whole country. So Lok Ayukta is again a representative, an ombudsman for states. So the answer is Lok Ayukta. So anti-corruption ombudsman organization in Indian states. Ombudsman is nothing but a representative, that is caretaker of the people. So Lokpal is something which is for India as a whole, whereas Lok Ayukta is for states. So moving to the next question, again ask the following. So yes. Administrative tribunals. Yes, in Indian Constitution there is an express mention about administrative tribunals, that is under Article 323 and 323B of the Constitution. Yes, representative, as we have already discussed, it's with respect to ombudsman, caretaker of the people. Then active role of judge in investigation. This also we discussed when we discussed about inquisitorial and adversarial system. So when judges take an active role, it's an inquisitorial system, whereas in adversarial system, court or the judge try to hear both the parties and then only they'll come to a conclusion. So that's it. An alternative dispute resolution technique, it's a non-adversarial techniques of adjudication. So the answer is B. So moving to the next question, arrange the steps to become an advocate on record sequentially. An advocate has to take an examination for becoming an advocate on record. Yes, that is there, that we discussed in one of the previous questions. Then advocate must have 5 years of standing at the bar. An advocate must be trained under advocate on record for a period of 1 year. Then an advocate must acquire an LLB degree from an institute accredited by bar. Of course, then advocate must acquire an LLB degree from an institute accredited by bar. So yeah, another interesting thing that is with respect to almost all the options that we discussed in earlier thing was that if you know any of the one step or one thing clear, it's easy to answer the options like this, because there's no other option that is starting with A. So even if you're not really aware about other aspects, it's easy for you to pick from this. So, okay, sorry. First and foremost thing is, an advocate must acquire an LLB degree from the institute that is accredited by bar. Yes, so D. So it would be D. Then an advocate must have 5 years standing at the bar. So that is the qualification that would actually make him or her to write the exam. So if it is proven that he is having a 5 years standing at the bar, then he can actually apply for the AOR exam. So once he completed the AOR exam, and if he qualified for the same, then he should be trained under the advocate on record for a period of 1 year. So the answer is C only. My mistake. The earlier thing was just got confused with the option A. Sorry. So again, no. So yes, if you're clear with any of the option, it's easy for you to answer. So yeah, an obvious answer would be C only, because so whatever it is, even for an AOR, just to practice as an advocate in high court or like even lower courts, all you need to have is a law degree. So yes, and that too, it should be from the institute that is accredited by the Bar Council. If not, that degree will not be valid. So yes, moving to the next question. Under Legal Service Authorities Act 2002, permanent local adalats that were established to settle disputes concerning. So what was the intent behind the permanent local adalat when it was established? Private utility services, public utility services, sexual harassment at workplace, and human rights violation. Permanent loc adalats. For human rights violation, we do have National Human Rights Commission and State Human Rights Commission. Sexual harassment at workplace can be also something which can be taken to court directly. Then private utility services, no, it's between private parties. So the answer will be public utility services. So this act actually provides for the various provisions of dispute settlement through lok adalat. So that constitutes legal services authority so as to provide free legal aid and competent legal services so as to the bigger section of society, as we have discussed. So there was an amendment in 2002 to this act, which actually established a permanent lok adalat for public utility services. So the answer is public utility services. Yes, Amrita, the answer is C. It's option C, public utility services. So moving to the next question. Which of the following is not a statutory function that is performed by the Bar Council of India? So Bar Council are empowered with certain rights. At the same time, there are certain functions that is to be okay, just one second. Okay. Sorry. Yes. So there are certain functions that is to be performed by the Bar Council of India. So the separate functions. So Advocates Act of 1961 provides for the functions of Bar Council of India as well as State Bar Council. So under that, which of the following is not a statutory function? So organizing legal aid for poor. Yes, that is a function. Then promotes and supports law reforms. Yes, that is also there. Then conducting seminars and talks on legal topics by eminent jurists. Yes, as a part of training, BCI, Bar Council of India, is obligated to do all these things. but however to conduct LAM fellowship. So LAM fellowship is a fellowship that is under the PRS legislative research. So for public policy, they are involved with the public policy aspect. And so what can I speculate? So the answer is option A, to conduct LAM fellowship programs, because that is not coming under the purview of Bar Council of India. Because Bar Council of India actually regulates the legal education as well as the legal practice in India and nothing else. The LAM fellowship and all, it's a prerogative that is coming under the legislative research. So moving to the next question, arrange the 4 pillars of human rights in India in the court sequence as they appear in the Constitution of India. So preamble, what is the preamble? So it represents as a prelude to the Constitution itself. It represents the principles of Constitution and indicates the sources of its authorities. So preamble is the very first thing that you can see in the Constitution of India. Then comes the fundamental rights. Fundamental rights are from Article 12 to 32. Then we have fundamental duties coming up till Article 51, and directive principles of state policy follows the same. So fundamental rights are rights that is guaranteed to every citizens of India. Then fundamental duties. So whenever there is a right, it should have some duty as well that is to be followed. So fundamental duties. And then directive principles of state policy, that is the directives for states so as to provide for certain aspects to the citizens of India through various programs like equal pay, equal work, then uniform implementation of uniform civil code, etc. So fundamental rights, fundamental duties, and directive principles. So when you look into that, so fundamental right is having utmost importance. So whenever there is a conflict between fundamental rights or fundamental duties and directive principles of state policy, it is always the fundamental rights that will prevail. Because rights that is guaranteed to citizens is the supreme rights. Even if there is even if an individual fails to perform the fundamental duty, but there is a leeway, so that fundamental rights would weigh over fundamental duties. So moving to the next question, which of the following is rooted idea of providing free legal aid to the poor by the state? So it's the 14th report of the Law Commission. It says that is the so that was the 14th report of the commission actually mooted the idea of providing free legal aid to the poor by the state. So, yes. So, final question for the day. A judicial decision has 2 parts. One is obiter dicta and the other part is that is binding on the parties. What exactly is that called? So, locus standi, it is the right of the party to represent in the court, as we have already discussed. Then parimateria. Parimateria in the sense that it is dealing with the same subject matter. So ratio decidendi is the principle or rule on which the court decision is found. And stare decisis in the head sense, it is to stand by the things that is decided. So if it is already decided by the court, it would become a precedent. So it is obligated. So once the Supreme Court decides a certain facts of issue in a certain way, that is to be something which is followed by the other courts as well as Supreme Court in India, wherein like the issues or factual scenario is same. So that is the precedent, that part that would be coming under stare decisis. That is to stand by the things decided. So it is pertinent to stand by the things that is already decided unless and until it is overruled. So when a specific things are already said, it is to be abided. So the answer for this thing is ratio decidendi. That is a judicial decision that is having two parts. One is obiter dicta and the other is ratio decidendi. Ratio decidendi is a rule or principle on which the court decision is formed. So this is binding on the parties. Obiter dicta are just the passing comments that is made by the judge. It's not something which is to be adhered to, but if it's just a passing comment that is made by the court. So that brings the end to the session. So these were the sample questions from the previous year CUET legal studies paper. So just to a few tips for cracking legal studies paper. It's just that just try to solve as many as more papers available, as well as there is nothing that is outside the syllabus. So stick to that syllabus as well as refer to NCERT textbook. Almost all the questions that I discussed today was from NCERT textbook only. So just stick to your NCERT textbook. That should be your primary source. And after the reading and after understanding the concept, then try to do mock papers as well as sample papers. Actually, you can download the mock papers from NTA official sites. So these questions were taken from NTA official site solely from a sample paper that was released in the NTA official site. So yes, that's it. This brings to an end of the session. Thank you.